we have had some year here on the No State Project, and those who have come to markstevens.net for help on how to defend themselves. Because if you want to learn how to effectively defend yourself, and I know someone just corrected me again, I guess because we've had success in Israel, then that would actually be 4 continents, not just the 3. So we have 4 continents going. But if you want to learn how to effectively defend yourself, definitely check out this broadcast and the archives we have at markstevens.net and the videos. And of course, most people watching now are watching on YouTube. So you have my YouTube channel, which is No State Project. And what we do is we go through the Socratic method. And so this, I mentioned on the Skype chat, the No State Project Skype chat, that this dismissal had something that, it was an extra bonus to this dismissal. Because anytime you have an opportunity to show one of these lying critics who have to lie about my work instead of just addressing it head on, one of the lies that got someone banned is, and this will get anybody banned, if anyone turns around and wants to criticize, that's fine. Criticize the material, but get it right. Don't lie and don't straw man the position. Actually address the position head on. And it doesn't mean anything to say, well, the court turned them down. Just because someone gets turned down in court doesn't mean that they're wrong. Gitlitz versus Commissioner, Gitlitz was defeated every step of the way until he got to the Supreme Court. And then the Supreme Court said that everybody else was wrong. So just because a court disagrees with you doesn't mean you're wrong. It just means you've got some people who, for whatever bias, they're not actually addressing your argument. It's just like saying that asking for evidence is a frivolous argument. No, it's not. It's a tactic. It's a way of defending yourself. It's not an argument. The argument would be, after I asked him for evidence and he didn't have any, I concluded that he doesn't have any evidence to support his conclusions and that he's arguing without evidence, and that would be a due process violation. That's the argument which is supported by evidence. And it's not frivolous. I could be wrong. Maybe there is evidence, but that's why we stick so hard to the evidence. We want because questions of fact are never frivolous. Never frivolous. And that's because to be frivolous has to be so lacking in merit, it requires no demonstration. So the fact that you have to produce the evidence shows it's not frivolous. You're wrong, but it's not frivolous. Frivolous does not mean, someone who disagrees with me. If someone has a contrary life belief or a belief or a contrary argument to yours, that doesn't make it frivolous. But when you have a vested interest in this criminal system called government, then you can't even allow that anyone that has an argument against you can't even allow for the possibility that it has merit. Frivolous. So that's what they must do, is teach these lawyers, especially district counsel for the IRS, that anytime that they are supporting the IRS or defending the IRS, they're probably taught, all you got to do is start screaming frivolous from the rooftop, and the judges will bend over backwards to support you. Frivolous, frivolous, frivolous. Questions of fact, not frivolous. Could be wrong, not frivolous. Brett in California. This is criminal traffic in California. And where did this, I'm not on the other computer, so I don't remember exactly where in California this was from, but it is in the Justice Court. And it was a Judge George Hernandez. And it was Police Officer Osteen, who was present in the court. Now, what happened up to this point was, what we typically do, and Brett did this, he filed in California, it's still called a demur. So the motion to dismiss for lack of evidence proving jurisdiction and a valid cause of action is called a demur. And if you look at I have the government code somewhere, I'll get it in the video. A demur is appropriate when you are attacking the factual sufficiency of the complaint, that the facts as alleged do not constitute an offense. And so basic common sense dictates over here that if there's no factual allegation showing that the rules applied, then it's factually inaccurate, factually insufficient to just say, well, we have this rule and he violated it. Well, do the facts show that the rule applies in the first place? If it doesn't, factually inaccurate, and that's why you do the motion to dismiss or a demur. We also have with that a request for judicial notice, because we're trying to make it more difficult for the judge to just outright deny or overrule the demur. Because one of the things we want to show in there is that, yeah, the California court system, like all the rest of them in Canada and the United States, they're all adversary systems. There has to be an actual adversary. And so we've had them, and I wrote in Government Indicted that some judges just like this Judge Hernandez, just deny it. See, because they're not actually reading it. Yes, you don't have to take judicial notice of everything that's in the motion. Of course not. You can, there's a number of different sections, and the judge can say, well, I'm going to take judicial notice of 1, 2, and 3. I'm not going to take judicial notice of 3 and 4 because it's just not true. But to deny that's an adversary proceeding, you got one other thing left over there that I can think of, and that would be inquisitorial, where there's no presumption of innocence, because that's where all logic is thrown out. And that's where the presumption of innocence comes from. It comes from the fact that the burden of proof is on the accuser, and that until they have evidence to support their claim, you're presumed you're innocent, because you got to have some damn proof. So there was also the Brady/discovery request. And again, I'll review this every show. Brady material is information that shows that you're innocent. Any information, including impeachment evidence information that would show that the witness against you or witnesses against you lack personal knowledge or are not otherwise qualified, competent, or credible witnesses against you. Now, there is no prosecutor in this particular one. It's all done by the police officer. So he wrote the ticket and he's prosecuting this. So the judge at a pre-trial hearing denies everything. No explanation that I'm given. Just denied. Denied. But there was no response. Well, he was denying the demur and the motion for judicial notice. Again, the judge is denying it's an adversary proceeding. So he's also denying that a corpus delicti, according to the California Supreme Court, is required in every criminal prosecution. I know. They say every criminal prosecution, but then they start carving out exceptions. But, for taxation, we don't have to. Then stop saying for all criminal. All means, everyone. So Brett follows up the lack of discovery and Brady material given by the police officer, because this is what I think we should do. You file with the police officer at the police department, because he is the prosecutor. He has made the accusations and now he's prosecuting. He's not the prosecutor. If there's going to be one, has to file a notice of appearance. At least in Arizona, Rule 13 of the civil traffic rules. But they still have to put in some. They have to notify you that they're on the case. So we don't get a response back from the police officer for the Brady and the discovery material. Now, the discovery material includes, of course, evidence that the police officer relies on to support his claim of probable cause and that the laws are applicable to you. Because again, critics, the handful of them that are for this show, and you'll probably get them on. Of course, YouTube is full of those cancer-given comments. You have to have evidence. Got to have the damn evidence. If you're going to say the rules were violated, you got to have some proof that they apply in the first place. And making an assumption, that's not evidence. Evidence. You have to prove it beyond a reasonable doubt with evidence, not an assumption. And like I've said before, if you start with an assumption, especially an assumption that sets the relevance for everything else, you cannot prove your proposition beyond a reasonable doubt, not starting from an assumption. Well, they're true because they apply because we said so. That's not evidence. So, because no evidence showing that the Constitution laws applied because he was physically in California was given by the police officer, and the police officer did not respond to the Brady request, because if he had evidence showing that he had personal first-hand knowledge of that, guess what? He's supposed to give it to him, to Brett pursuant to the discovery request. If he had the evidence. So, because he doesn't have the evidence, the Brady request, to be responsive to that and not violate due process, he has to lay out that he, as the only witness, doesn't have personal first-hand knowledge of these claims that he's testifying to. So what Brett did, and this is part of the package you get at markstevens.net, he filed what's called a motion in limine. Now, the motion in limine is a pretrial motion used to limit evidence and argument. So in this particular case, what we argue in the motion in limine is that if the prosecutor is alleging that the laws apply to me, but has no evidence and no qualified witness to support that claim, then they should not be allowed to argue, right? Doesn't that right? If we were making arguments against the prosecutor and we had no evidence, you could be damn sure that not only would they file a motion in limine, but the judge would probably threaten sanctions and contempt if you dare to argue that. In fact, we've seen that before. We've seen that with Mike in Idaho, where he was threatened by the judge not to raise a certain issue. And that's what a motion in limine does. So what we did was we laid out the evidence. Well, we asked him on such and such a day, the court has a courtesy copy, we asked him for discovery and Brady material. The police officer did not respond. What's his name? Yes, Officer Osteen did not respond to the discovery request. So, pursuant to his refusal to exercise good faith and provide the discovery and the Brady material, which of course is exculpatory evidence or information, goes to the competency and credibility of the witness, which is Osteen the cop who wrote the ticket. Now, come on. Now, if we're asking for evidence that the Constitution and Code apply, and if there's a witness with personal first-hand knowledge, Osteen is the guy. This isn't a matter of a prosecutor having to get with him and investigate and interview him and find out. He knows he doesn't have such proof. He knows he's just giving a gun and saying, go out and give tickets, okay? That's what he does. He knows better than anybody that he doesn't have any evidence to support his claim. Zero. Absolutely nothing. So it was no surprise. We've got the docket. Okay, I've got the minute entry order, rather. I have the documentary proof from Brett to prove this. So this is the extra bonus. Because not only did the police officer show up and request, and I'll have all this in the video. You'll be able to see this after the live stream. It says right here, this is a minute entry order from yesterday, September 5th, before the Judge George C. Hernandez. And it says, Officer Osteen present in court. Defendant present, that's Brett. It says, case dismissed pursuant to officer's request. Dismissed in the interest of justice. Defendant released, case closed. Save minute order to case. So, there you go. See, the bonus here, and again, we have the minute entry orders to prove this. So when they say to you, every single time a court has considered my material, it's been denied and described as sophistry. Yeah, you see, I have motions that were granted. You can see that at markstevens.net. I have the actual documents unredacted that you can look up. Here, now, yes, it was the officer's motion. He motioned to dismiss, and that's what was granted, and so the ticket was dismissed in the interest of justice. Yeah, because he never liked to stand on. He's a lying predator. But what the minute entry order will show that I'll have up is that the motion in limine was granted. Okay? It wasn't described as sophistry or sophistry. It wasn't described as frivolous. It wasn't described as legalistic gibberish. We showed that the police officer did not give the discovery. We showed he did not get the Brady material. We argued that pursuant to, fairness and due process, that no one should be allowed to argue without evidence. And the judge granted the motion in limine, which limited the police officer's testimony and evidence, if any. The motion in limine, which I wrote, specifically states that they should not be able to argue that the laws apply to us. Granted. Again, minute entry order from the judge will prove this. So no wonder. Imagine the police officer has just received an order from the judge. He can't even argue that the laws apply. He can't even argue jurisdiction, which means he can't argue probable cause. Because he has no probable cause that the code was being violated, because he doesn't have a shred of evidence to show it applies. It's an assumption. It's a damn assumption. That's all it is. Or what I like to call speculation. But from now on, it's not speculation for this police officer. He's just lying because he knows he doesn't have the proof. And Osteen is going to go back out there on the street and make the same legal determinations against other people. And we already know he doesn't have any evidence. What are they going to do? They're going to pull him off the street? You think he's going to have a crisis of conscience? So what he did here, he realized, I got an order from the judge. I can't even say that Brett is subject to the laws of the state of California. I can't argue probable cause to pull him over. I got motion in limine was granted. So what do you do in a situation like that when the judge is actually saying you cannot argue the foundation of your case? Well, you do the only thing you can do and save face. Because obviously if the judge granted the motion in limine, we've got a serious contradiction here. Why is he granting the motion in limine but denying the demur? But it was pretty clear. Maybe just figured, all right, the police officer obviously did not respond to the discovery request, and because of a lack of discovery, I've got no choice. I'm going to have to grant the motion in limine, which orders the police officer not to argue that the laws apply, not to argue jurisdiction. Well, it's a code violation. If you can't argue that the code applies, you cannot argue that it was violated. Sorry, but that's the way logic works. And if I was to say that my rules were violated by one of the critics, they go off on goal because your rules don't apply to me. That's right, because I have no evidence, as much as these people who call themselves government. No evidence. If they had the evidence, they would provide it, and the judge wouldn't go and file a motion, grant a motion in limine. So the police officer, this Osteen, only thing he could do was file to withdraw. Congratulations to Brett for standing up to these predators and getting this thing tossed out, not getting discouraged that the judge just initially denied or overruled the demur, and the motion for judicial notice. Because look, the denial of the motion for judicial notice sets the stage. You now know how dishonest this judge is. He's not even reading it. And why isn't he reading it? Because he's so biased, typically in favor of the cop. All they're doing is collecting revenue. All they're doing is collecting revenue. But again, congratulations to Brett for getting this thing tossed out. And that's the thing about police officers. So what I want to discuss here, because I'm sure there's other people saying this. I'm not one of these nobody's talking about. I can't stand that kind of clickbait garbage. Well, no one's talking about it. No, that's almost never true. Whenever you see a video or someone starts it off with, no one's talking about, shut it off. Just turn off the video. I'm sure there's people have spoken about this, but I want to discuss this because I haven't necessarily seen that. This whole thing about what happened with, was it Nurse Wubbles, I think her name was, in Salt Lake City? So this has exploded. And the hospital, not only was this guy finally put under criminal investigation, man, we know where that's going to go, but he's still actually a cop. Now, for those who haven't seen it, basically what happened was a police officer named Payne in Salt Lake City was at the hospital trying to get a blood draw on the victim of a horrific car accident. So the Salt Lake City police, I guess all police in the Salt Lake area, were violating, from what I understand, policy and going and doing a high-speed chase. Well, the individual they were chasing wound up hitting somebody, he died at the scene, and one of the victims suffered severe burns, was taken to a burn unit at a nearby hospital in Salt Lake City. Well, this particular cop, Payne, did not like being told no, and so he wound up arresting a nurse, Wubbles, who actually was an Olympic skier, I believe, a number of Olympics ago, and now she's a nurse. And the video came out a month after, because the police, it took them four some odd weeks to release this videotape surveillance so we can see it. The police chief, when you see them, they already knew about this incident for 4 weeks before the video was released. I'm surprised they even had the video to release, because so many times there's a malfunction and things, footage like that is always lost. So I'm surprised that they released it in the first place. But I think the reason why they probably released it in the first place and that nothing was done to this police officer is for the simple fact that this police officer is not a bad apple. This Officer Payne is a typical cop. He did what most cops would have done in the same situation. What it came down to is he wanted a blood draw, and he wasn't going to take no for an answer. It didn't matter that the hospital and the police department already had some kind of agreement about this. Now, I know there's some gray area potentially for the fact that if he was really a commercial driver, that there's implied consent when you get a driver's license, you get a commercial driver's license. So the issue had to do with the fact that he couldn't give consent. The police may have been looking at it from a standpoint, he gave consent when we allowed him to have the driver's license. Now, look, obviously there is no implied consent when you force somebody to do something. You cannot make a living doing this if you do not comply with that. So to say that there's implied consent, I mean, no. There's no implied consent when something's done under threat, duress, and coercion. Sorry. But bottom line is this police officer went through the force continuum. And there's no doubt that, in my mind, and from what so many of us have seen in person and with video evidence, that this police officer is not a rogue cop. This police officer, Payne, did not do anything unusual. What's unusual is that the video got out. That's what's unusual. It's unusual that not only that, but he is on a criminal investigation. Well, nothing's going to happen because he followed protocol. Yeah, people are outraged, and maybe there'll be a few thousand people woken up to the reality that this is standard police behavior. So I think one of the chief doctors or administrators at that hospital issued an order telling the police officers to stay away from their nurses and they're not to go into certain parts of the hospital anymore. But I want to make clear is that this is typical police officer behavior. They are not taught to treat us as equals. Anyone who's known a cop, anybody who's a friend or family, they're not trained like in the military. They're not trained like firefighters. They're not trained like EMT, regular first responders. They are trained to take and keep control. And if they start to lose that control, they have to go through the force continuum. And that is to use more and more force until they get compliance. Now, that does not mean for a second that the force continuum is being used because their life is in danger. You don't need a force continuum necessarily for self-defense. If someone is physically initiating attack against a police officer, even I'll say, it doesn't matter who the victim is. The victim has every moral justification to use the amount of defensive force to neutralize the attack. But that's not what the force continuum is about. The force continuum is about compliance. So here you see in the video, he says, that's it, we're done. This man, very short fuse, doesn't like being told no, didn't matter why she was doing it. She was very nice about it. She said no. And that is contempt of cop. How many times do we have to see things like this before the average person says, you know what? There's a serious problem here. And I know the mainstream media, which is almost worthless, will say, there's got to be better training. No. That's like, you have a criminal organization. Criminal organization. Why do we say that? What is the evidence? What are the facts? Police officers are part of what's called the state government, and they have no voluntary support as far as monetary support. It's all coerced. No one had a choice on whether there was a government or not. Governments have always been by conquest. Always have been, always will be. Because if it was voluntary, it wouldn't be a government. Because you wouldn't have taxation. Forcing strangers to give you money is wrong. It's criminal. It is wrong. It is robbery. It is stealing. Just calling yourself a government doesn't change that. If it's wrong for me, it's wrong for you. And if it's wrong for us, it's wrong for Mr. Payne. Payne being the police officer who initiated that attack against the nurse. Yeah, someone saying the evidence is the fun under all the paperwork. It's the gun. It is definitely the gun. That's why police officers tend to act the way that they do. Because they're gone, they are given a gun, they are taught that they are in control, they have to maintain control, and that people should die to maintain that control. Because what do police officers, what do they say? They're the ones that are making it home that night. They're the ones who get to go home to their family that night. And if you get in the way of that, you're the one who's going to die, not them. Not the way real first responders, real adults look at it. Firemen don't say, and soldiers, which I was at one point a soldier. Soldiers don't say, hey, I'm going home tonight. I don't give a damn about you. What's important is that I get home. No, that's what the cowards say. That's what the cops say. I get home tonight. Have you ever heard of firemen talking that way? Firemen are, you're going to get home tonight. My job is to make sure you get home tonight. This idea that cops say, well, we put our lives on the line every day. No, you don't. Because you're important. The most important thing to you is that you get home, not the people that you think that you're out there to protect. Because I got news for any cops watching. There's absolutely no duty for you to protect anybody. There's no duty of protection, and there's no duty of allegiance for me or anyone else to comply with your rules. The only rules that we have to comply with are the basic principles of right and wrong we learn by the time we're 4 or 5. We don't need someone in Washington, D.C. to tell us right from wrong. You do. It's these police officers. Because their whole concept of right and wrong boils down to legal and illegal. And then whatever they, as part of the protection for the oligarchy, the foot soldiers for the oligarchy, whatever the oligarchy allows them to get away with. There's no way in the world you or I could have done that to that nurse and we walk away that day. There's no way we could pull up on a 12-year-old boy and shoot him within 2 seconds and walk away that day. We can't just unload a firearm into the driver's window of a car because we think somebody's smoking pot and we walk away that day. Cops do it every day. So this police officer, Payne, well, he rightfully will never have should never have a job again. He's a scapegoat for the system. They're going to just lie and say he violated this, he did that. He did exactly what cops are trained to do. You don't get compliance, you go up the chain, you go up the force continuum, and you use whatever physical force, including deadly force, to get compliance. Because what if all the talking heads in the media say? Well, you should have just listened. Should have just listened. All right, give me a break. All right, my name is Marc Stevens. You've been watching the episode 33 of the No State Project live from the fortified compound in Mesa, Arizona, here on my No State Project YouTube channel. I appreciate everyone tuning in live. I will get the audio for this up today, and the video will be posted, obviously, at YouTube, but I'm going to have a couple of sections of the video separately that I have on the good camera, because I want everyone to be able to see the documentary proof of Brett's dismissal. So that's big. We had the motion in limine that was granted, which limited the cop from even arguing the laws applied. So the cop did the best thing available to him. Just drop it. Just drop it. So big congratulations to Brett for standing up to these to the bullies and getting me the documentary proof. If you got a ticket or you want to learn how to defend against the ticket, you may contact me at markstevens.net. Keep watching the show, the broadcast. I got a ton of articles and information at markstevens.net. Government Indicted has a full model available on how to effectively defend yourself, that we now have more evidence practically every week, more evidence of people replicating the success that we've had so far on 4 continents. So that, yes, 3 continents, including Israel. So thanks to Eyal of No State Project Israel for the support and for going up against the predators over there in Israel and getting us some success stories. We will be live on Saturday. So till then, salud.